Canadian Aero Service Ltd v O'Malley. Canadian Aero Service Ltd v O'Malley SCR 592 is a leading civil case decided by the Supreme Court of Canada on corporate director and officer liability. Facts. Canadian Aero Service Ltd. Canero was a company whose main business was topographical mapping and geophysical exploration. O'Malley and Zosky were senior officers of Canero and, together with Wells, were directors of the company. After the acquisition of Canero's parent by Letton Industries in 1961, Wells resigned as director in February 1965. O'Malley and Zosky resigned from their positions in August 1966. Wells was aware the latter were discontented at Canero by reason of the limitations upon their authority and the scope of independent action imposed by the Letton Company, and they also feared loss of position if Canero should fail to get contracts. Prior to their resignation, at the suggestion of Wells, the three decided to form a business venture in the same fields as Canero. It was incorporated as Aero Service Ltd in September 1966. In that month, Aero was chosen to receive a contract to perform a topographical survey and related mapping for the government of Guyana, and the agreement was executed in November 1966. The proposal upon which the contract was granted was based on preparatory work that had been performed by O'Malley and Zosky for Canero prior to their resignations. Canero filed a claim against the three together with Aero on the basis that the defendants had improperly taken the fruits of a corporate opportunity in which Canero had a prior and continuing interest. The issues. The determination of the relationship of O'Malley and Zosky to Canero, the duty or duties, if any, owed by them to Canero by reason of the ascertained relationship, whether there has been any breach of duty, if any, is owing, by reason of the conduct of O'Malley and Zosky in acting to Aero to secure the contract for the Guyana project, the question of liability for breach of duty if established. The judgments below. In the Supreme Court of Ontario, it was held that, while O'Malley and Zosky, as corporate officers, have fiduciary obligations to Canero, such obligations did not apply in this case. As the trial judge Grant J. said, the judgment was affirmed on appeal to the Court of Appeal for Ontario, but it was held O'Malley and Zosky did not have fiduciary obligations to Canero. Instead, the relationship was simply that of employees and employer, involving no corresponding fiduciary obligations and, apart from valid contractual restriction, no limitation upon post-employment competition save as to appropriation of trade secrets and enticement of customers. Decision of the Supreme Court of Canada. Appeal was allowed for all but one of the defendants. The court held that anyone in a supervisory or controlling role of a company has a fiduciary duty towards the company, which includes the duties of loyalty, good faith, and avoidance of conflict of duty and self-interest. As the court noted, significance. The case significantly extended the reach of fiduciary duties that had been previously recognised in Canadian law by Pace Silver Mines Ltd v Cropper, which had adopted the principles of Regal Hastings Ltd v Gulliver. These principles have been furthered in subsequent cases, most notably in People's Department Stores Inc. Trustee of V. Wise. Aero Service and Pace Silver Mines continue to illustrate the boundaries of conflict of interest that directors of Canadian companies must keep in mind in their deliberations.